So just to make sure that we're all aligned, our goal today is not to infuse unnecessary fears. And this is why we had some relaxing, cool Beyonce tunes. But we want to channel any concerns into actions with this collective intelligence of this group and the guidance of our legal experts tonight. So I am Tom Divon. I am a platform researcher and a PhD student at the Hebrew University of Jerusalem. Like you, I am curious about the DSA, but I also have a tremendous fear of both roller coasters and legislation. So today is a form of shock therapy for me, but hopefully not for you. And now I'll hand it over to my friend and ride colleague, Taylor Annabell, to set some of the context.
Hi, everyone. I'm Taylor. I'm from Utrecht University. And like Tom, I think have this curiosity and interest in understanding the DSA, and similarly to him, have a media studies rather than a legal background. So I'm excited to be on this roller coaster with you all, although I do like roller coasters, so the metaphor really fits for me. And in the multidisciplinary team that I get to work with at the moment, I really benefited from having opportunities like this to gather with scholars who have really different backgrounds, and in particular to think through what regulation means with experts from the field. And so that really brings us to the premise of these workshops that we're curating for you. And I want to say a few things, I guess, about the premise from where these come from. So I guess we're probably all familiar with the way that regulation has garnered quite significant attention in media studies, but the kind of complexity and challenge of translating what this legislation means. And so the Digital Service Act is this crucial piece of legislation that is redefining platform liability within the EU. And there are some very optimistic expectations around the kind of impact it might have. And our goal over the course of these workshops is to demystify some of what's going on and clarify what the DSA is all about by delving into some of the specific underlying legal standards and provide an opportunity for us to gather together as a community to discuss and to question what types of implications the DSA may have for media studies research and researchers. And so we're going to kick off with our workshop today, where we hope to set the stage by providing some legal knowledge, thanks to the expertise of two amazing scholars, Catalina and Jakob. They're going to begin with a presentation that contextualizes the DSA in terms of pre-existing regulatory approaches, particularly in the EU. They're going to briefly outline the structure and the objectives of the DSA and offer some examples of provisions. Then Tom and I will be back to offer some brief provocations for how some of the concepts that emerge from the DSA might be significant and relevant to the field of media studies. And then we want to open it up for a discussion with us all here, where we want to invite you to contribute your responses, questions, and concerns. So now I have the pleasure of handing over to Catalina and Jakob, who are going to begin our DSA roller coaster ride. So over to you both.
Thank you so very much. And thanks so much, Tom and Taylor, for also putting this together. I think Tom was the one with the initial idea, also based on a Twitter exchange with Sonia Livingstone about, what exactly is the DSA? How does it work? Do we have reasonable expectations from it? And I must say, also as a legal scholar myself, having done quite a bit of multidisciplinary research, I tend to sometimes be perhaps overly optimistic about new regulation from the European Union, but then sometimes also very, very negative about it. And that's something that I've been sharing with Jakob. Maybe Jakob, I don't know if you're available to turn your camera on for 1 second. There you go. Jakob is now he's at in Amsterdam at the Vrije Universiteit. But I'm Catalina Goanta. I'm an associate professor at Utrecht University. As I mentioned, a legal scholar doing also work on platform governance from a legal perspective. And I have the great pleasure to work and co-author together with Taylor, with Tom, and to also do research with Jakob. And Jakob, do you want to present your research a bit and to introduce yourself?
Yeah, I suppose I can. I hope you can hear me, by the way. Good. So I'm Jakob. I'm not a media studies scholar by any means. So all this is pretty novel to me. I'm a legal scholar and I study freedom of expression on social media platforms predominantly. And so for me, the Digital Services Act, which we're discussing today, is this huge sort of key cornerstone of everything that I've been doing for the past year and will be doing for the coming few years. And I'm a PhD researcher at Utrecht University, but FU is closer to my home, so that's why I'm here.
Wonderful. And tonight, what we're going to do is we're going to have a 30 to 35-minute presentation, which we really encourage you. We don't want to have like a lecture or something. We really encourage you to interact with. We're going to use quite a lot of the concepts from the regulation itself, from the Digital Services Act. It might look a little bit legalese at times. So that's why, please, there are no questions that are off the table. Whenever you feel like, I don't understand that word, just, go ahead and ask us. Let's get into some conversations. We also looked at some of the points that you were interested in. I know some of you in the room, and I know your research, so perhaps I'm going to try to make some bridges to that. But we have selected some examples, but we're very happy to discuss further examples, not just tonight in a very large Q&A, but also in the next sessions. And perhaps we can also just use this as an organic ability of improving the next two webinars, because I've been doing these kind of webinars with computer scientists, so law for computer science. And this was, I think, one of the most motivating activities that I've done in my career so far, interacting with new communities and understanding how to translate what I know into a new form of expression for instance, now media studies and platform governance studies. But then also, I think Jakob and I are very happy to learn from you and to understand different perspectives and different angles that the very rigid and sometimes very boring law can be looked at. And perhaps, Tom, if you could just enable my share screen, I can start with the presentation. We have some slides, and then I'll be presenting some things and then ping-ponging to Jakob for some very nice commentary on fundamental rights. And maybe this is something that I need to mention. So as a legal scholar, and I'm sure that media studies and then platform governance studies have these clusters as well. We have these very clear, because law is a very old discipline. So we have these very clear turfs in law. So I consider myself a private scholar. So I do private governance, consumer protection, everything that deals with bilateral transactions, whereas Jakob is an expert in freedom of expression and fundamental rights and constitutional law. So I think that together you can also hear different perspectives so that we don't brainwash you in just, one way of looking at the law. Because especially with the DSA, that is going to be, this lack of brainwashing is actually going to be quite important. So we have our series. We have 3 webinars prepared for you. And then the first webinar is supposed to be about introducing the DSA. And tonight, what I think we might be benefiting from and what we could benefit from is kind of a 3-fold structure. First and foremost, to set the scene and to also understand what is the background of this reform, because the DSA didn't just happen overnight, and it didn't happen in a legal vacuum. There's actually another piece of regulation that is very important to know, and because this will also, I think, and I don't know if Jakob agrees with me, I mean, there is case law on this old e-commerce directive that we will talk about. So the DSA will also be bound in a way to be interpreted in the light of what the e-commerce directive has laid before itself. So that's why I think it's very important to look at the background. Then we are going to discuss a little bit the structure and objective. I think that this is going to be the most straightforward and the clearest part of the presentation. And then we will go through 3 examples of provisions, but like we said, we can also discuss further examples. So once more, please stop us at any moment in time when you have questions and when you would like to ask anything. Before we begin, kind of a background on the regulation of anything that happens on the internet. The internet as a technology has led to quite a lot of interesting legal developments and also a lot of interesting legal questions. But if we think about how the internet also developed worldwide, particularly, let's say, in the 90s, and also kind of going into the dot-com bubble at the end of the 90s. Nobody really knew what to expect from the internet, and nobody really knew what kind of harms and what kind of issues were going to be coming up on the basis of internet technologies. So that is why, generally speaking, in the European Union, there has been this kind of laissez-faire approach of, you know, let's just leave companies that deal with different types of digital services and that offer all sorts of business models on the internet. Let's just let them develop, and then let's see exactly how we are going to regulate them when harms occur. So there has been this concept of, let's not just put regulation as a burden. Let's not just create regulation just for the sake of creating regulation. And of course, the idea of how e-commerce would be able to facilitate the exchange of goods and services cross-border, that there should be, you know, no considerable limits to that, that there should be this free transfer of goods and services across different borders. That was something that was very much at the center of the regulatory vibe, let's put it like that, at the end of the 90s and the beginning of the 2000s, particularly in the European Union. I am not very familiar with specific developments in regulation, for instance, in California. At that time, there is a very important provision that perhaps we can go into and compare with in terms of US law and platform liability. But I think that it's perhaps one of the most important messages also for you tonight is that regulation is also something that is very, very local. It's right now we do not really have like an internet treaty. So that's why I will keep on referring to what has been happening in the European space, because that might be very different than what has been happening, for instance, maybe in different Asian countries or in Australia or in Canada or in the United States or in Brazil. So when it comes to the European Union space, there was also this idea of, okay, we are going to see a lot of intermediaries being developed in this internet space. So should we really hold any kind of platform liable for material that is posted by other parties than this platform that they do not really have a lot of control over? And the problem is that if we did consider this type of liability, that would have completely killed off a lot of business models and also just a lot of companies. Imagine if we look back in time and if we did have this type of very heavy burden on platforms like eBay or Amazon, perhaps they might not actually exist today. So the idea of trying to not necessarily protect, but maybe more like give what I like to call a regulatory subsidy. So basically being a little bit more lenient with different types of companies. This was reflected very much in the first type of regulation that was adopted on platforms in the European Union, dating from 2000, which is this e-commerce directive, which is a little bit of a misnomer. But we will come to that as well. Did anybody hear about the e-commerce directive in our audience tonight? Any media scholars who heard about the e-commerce directive? Yeah, Rebecca, what do you know about it?
Yeah, I only read about it let me think, in some legal paper about e-commerce but I don't know more about it, honestly.
Great. So we have some good slides for you that you can always come back to. And also perhaps we should mention that if you're interested also in literature on these topics, we can provide you via email a list of readings that perhaps are basic readings in this respect. So when it comes to the e-commerce directive, the reason why I'm saying that it is a little bit of a misnomer is because as a consumer scholar, when I hear about e-commerce, I hear about, okay, you have someone who wants to buy something on the internet, right? So you have someone who wants to sell something on the internet, and you know, what are the rights, what are the obligations of the people who engage in these kind of transactions? But actually, the e-commerce directive wasn't about that. The e-commerce directive was very much about well, two main things. First and foremost, what we call in law information duties. So these are obligations on different parties, like companies, mostly in consumer protection, of disclosing certain things, disclosing information about themselves. And so that is something that is supposed to improve transparency and trust in these online markets. And then the second thing that was very much at the core, or still is, because we still have it amongst us, the e-commerce directive. So it hasn't gone anywhere, but it has been slightly modified by the Digital Services Act. The idea of limitation of liability for intermediaries. So having online platforms that rise as intermediaries, and then thinking about what kind of role there is for these intermediaries on the internal market. So the internal market is kind of like the economic space around all the member states in the European Union and the European Economic Area. And of course that because of the fact that this type of regulation wasn't this top-down regulation of, okay, now the state is going to check up on all of these companies and really do very harsh enforcement, it also included some very interesting provisions and also principles on self-regulation, so private regulation, which perhaps maybe is also a source. And I don't know if Jakob agrees with me, but I think that this is a little bit of a root of why we have so much private governance, because also platforms were given the space to develop their own rules. Jakob, would you disagree with that?
Yes and no. So giving platforms the space to grow sort of without responsibilities and boundaries has created a lot of problems. And I think the regulatory sort of toolbox for states was not equipped to deal with all of those problems. So at some point they just removed their hands and said, well, please, can you try and fix it yourself first? And then they had to actually step in with the DSA, as we're discussing.
Yeah. So that's a very interesting, that is going to be a very interesting interplay between, on the one hand, having a state or a supranational entity come in, step in and say, okay, we're going to regulate this field, but then also kind of understanding, well, can we really do everything in practice? Do we even have resources for that? I think in webinar 3, we will talk about the enforcement of the DSA, and there we can come back to this theme of the massive also power gap between the state and the digital industry currently. And but the one thing that I think is very important to remember here is that the e-commerce directive also created perhaps a little bit of a starting point for this mindset of let's also let the industry deal with some of these obligations itself. So then very briefly, the idea is that if we have these transparency information, the requirements, transparency-oriented information requirements, if we try to have some very specific provisions for online advertising or for spam, so this is the first official regulation in the EU on spam, and then the idea is that we can create this very nice harmonized market for digital services and content in the European Union. And something that we will come back to also in webinar 3 is the fact that the e-commerce directive already created this enforcement orientation, or the idea of where exactly are you going to be able to hold a platform liable, an information intermediary liable. You are going to do that on the basis of this country of origin principle. So this is in some literature it's called the internal market clause, but the country of origin principle is the idea that if we have Booking.com based in the Netherlands, actually, as it happens, then you're going to have an authority from the Netherlands that will be able to take measures against this company there. Otherwise, it's not going to be that easy to hold this particular company liable. So it is something that has been taken over also by the DSA. Some very specific examples. So these are information duties just to show you how they look like. Article 5 of the e-commerce directive. You can see that basically the directive just says, okay, just you're a service provider on the internet. Give us your name, give us your address, the geographical address, so that users know exactly where you're located, so that users can also understand how to relate to you, whether these users are professional or individual. And there has even been very interesting case law from the Court of Justice. For instance, there was a case once that was asking, well, someone doesn't have an electronic mail address on the website of their business, but they have a contact form. So is that contact form actually equivalent to an electronic mail address? And is that contact form also equivalent to a phone number? Because a phone number you can call at any time, whereas in 2000, maybe not everybody was checking an email every single day. So there are some very interesting developments in that respect. But again, this is an example of the information duties. And then the spam, so unsolicited commercial communication. Although I should also say that particularly this article that simply says, okay, let's regulate spam and then kind of prohibit spam. Then basically we need to make sure that we also link that to other provisions and also other legal frameworks that have been dealing with the more commercial and the more contractual dimension of e-commerce, such as this directive, which is a defunct directive by now. It used to be my favorite directive because it was like very compact. It was a directive on distance selling, and it was also about basically having information duties and also giving consumers the so-called right of withdrawal. That is what I would qualify as an e-commerce provision, but not necessarily the actual e-commerce directive. Now, some very interesting things about the e-commerce directive itself. It has also included these categories of intermediaries that it requires, or it recognizes a conditional liability exemption. So we have three important concepts of mere conduit, caching, and hosting. And what are they exactly? So mere conduit is basically an internet service provider that is simply just transmitting information. It doesn't really modify it. Another example of a mere conduit type of intermediary is a messaging service. So it's just about kind of transmitting information and not really doing anything with that. And there has been quite a lot of case law. I'm not very familiar with it, but there has been quite a lot of case law, for instance, on holding internet service providers liable for different type of illegal content. So if someone just manages to access the internet and maybe has a is doing so through a specific internet service provider, can we also hold that internet service provider liable? But then actually the internet service provider just connects you to a cable, so they're not doing anything more than that in terms of controlling what they can see from a user. Caching is something that is that I always find quite difficult to understand unless someone has a very, very consistent internet architecture form of knowledge. But I think that the best example of caching is the content delivery network. So it's about trying to make the internet, or trying to make internet communications more efficient by having this temporary storage of content on different servers and then reassembling it. And I think that this is very much geared towards kind of the performance of this type of transmission. And last but not least, we have hosting, and hosting is the most known and also the most, I think that this is, Jakob, if I'm not mistaken, I think it has led to the most case law also at the Court of Justice, right? Because I'm not familiar with case law on caching, because I don't think that there was any case on content delivery networks, right? No. Okay.
No, caching was sort of the odd one out. There wasn't really much need for any case law on that.
Well, good that we have it in the e-commerce directive, but nobody has interpreted that particular provision. So hosting can mean everything and anything. So it's about hosting websites. It's about hosting. I mean, like now also with cloud services, I think it has been incredibly, it has become very prevalent on the internet. But then, of course, also for media scholars, most importantly, it means that hosting will be a category that social media platforms will always fall on because basically they are hosting content that is provided by their users. And this is a paper, it's part of an upcoming book, actually. So it's a chapter written by Martin Husovec, who is a very, very prestigious writer on the Digital Services Act. So you should also follow him on Twitter for more DSA updates. And Irene Roche Laguna, who actually works for the European Commission. and has been involved very much in the drafting of the DSA. So they also give some examples. These articles are from the proposal of the DSA. So now we have other numbers, but basically we have the same discussion. So caching, content delivery network, near conduit services, internet providers, DNS authorities, Wi-Fi messaging apps, and then hosting services, the social networks, trading platforms, discussion forums, cloud services, and so on and so forth. Do we have any questions so far about the e-commerce directive? Anything? Let me just also look at the chat. No. So the main, question?
We do have something in the chat. We have a question, from, I'm not sure if it's direct, but Yarden Amir was asking the question.
Perhaps you can also ask it directly.
Yeah, I was just raising a thought that is not specifically directed to the e-commerce directive or the DSA, but for the early stages of regulation. I think you were talking about the space given to the platforms to evolve, and I think some of this is related to the fact that regulation in its early stages was kind of turning the blind spot towards them. The lack of importance reflected on them was in itself, one might say, something that made them grow this big or gain that much power.
Yeah, absolutely. So I think that here also from a regulatory perspective, and I think I should also mention that, right now we're talking also about the content of the law. So what Jakob and I will do, especially with the DSA, we will just look at the actual text of the law and then try to interpret it together with you, because I think for the DSA, it's going to be any interpretation goes, since it includes a lot of new provisions and that nobody really knows how to interpret. But I think in general, it's also important to remember that there's a very big field of so-called regulation studies, where indeed there's much more emphasis on, for instance, maybe the economic impact of regulation on different markets, and also regulation as an intervention, regulation in the form of self-regulation that will meet certain needs and focus on certain interests in particular economies, or command and control top-down regulation or co-regulation. So I think there's actually a journal of regulation and governance, I think it's called, that has quite a lot of materials on this. But I'm also very happy to include more additional readings in the readings that we can send, also not just in the chat, but also after the webinar is done.
Thanks, that would be great. Thank you.
Yeah, that's a very, very good point. And Claudio, you also had a point about the GDPR. Do you wanna talk a little bit about that?
Not really. I was just asking if the DSA has also a more powerful European authority, because one of the limits of the data protection authority in the member state is that sometimes they do not feel that they can be too hard against national companies. I was raising the example of Facebook for Ireland or Glovo in Spain. Yeah. I mean, of course, Facebook is in the US, but still bring a lot of taxes in Ireland, and therefore there is some, let's say, economic leverage. And thank you to the answer got from Christine and from Jacob. They were pointing out that the develop, so the biggest companies that will be supervised by the European Commission itself. But I don't know exactly what are the boundaries between the national action and the European one. So maybe at the third session, you said there will be some clarification on the enforcement.
Yeah, so that's a very good point, also the parallel with the GDPR, because it is true that indeed there's going to be this country of origin principle that has been very much adopted in the e-commerce directive as well. So according to the DSA, it's still going to be, the authority where the company is established, that it's going to be the actual authority that will supposedly take measures under the DSA. But there are some shared competences with the European Commission, indeed, especially for very large online platforms and very large online search engines. So, but we will discuss more about that in the third webinar. Yeah, so now maybe just already moving, so we spoke enough about the e-commerce directive, moving directly into the DSA. The thing is that a few years ago, and actually the e-commerce directive was revised several times, or at least there were some attempts of revision several times, and a few times, I think that this happened 3 times, and the first 2 times the answer was no, I think we are good still with the e-commerce directive. We shouldn't be too harsh on these kind of emerging platforms. We don't know exactly what is happening with them. We have a regulation in terms of platform liability in the form of the e-commerce directive, so let's leave it to that. But then as we saw how exactly the different business models in the digital economy developed, then it became quite clear that it wasn't enough to just have the e-commerce directive. So what happened is that in around, I think, 2022, so around 2020, the European Commission already started working on the proposal on different approaches, because I'll also show you the type of regulatory cycles that the European Commission is bound to. But basically, we have in 2020, we have, I believe, already the proposal. That is the 2020, that is the proposal. So it started working on that earlier, I should say. And then we have the full, and this is a typo, we have October 2023 when the DSA actually came into force, or when it was adopted, and then some provisions already came into force, and then some others will only come into force in 2024. So for instance, we have already provisions for very large online platforms, very large search engines on the DSA transparency database that we will also talk about in a second, that already have entered into force. So platforms need to submit their content moderation decisions, but then for all other online platforms, that will only happen as of February 2024. So this is what I was mentioning in terms of regulation, which is a little bit different than just looking at the law. So in the European Union, there is a so-called better regulation agenda. So this is about EU lawmaking, and it has different types of steps because we're speaking about, first of all, for instance, the Commission, and I'm not also an EU law expert myself, an institutional EU law expert, but there are many ways in which the European Union can start legislation, and one of them is, for instance, for the European Commission to start a little bit of a research project by which it starts looking at different impact assessments. So namely, looking at studies, sometimes even asking researchers to do studies on, is this directive still working for us? What are the problems in this directive? Then you have to do all sorts of interviews, speak to stakeholders, understand how to economically assess regulation. And then basically there is some sort of a roadmap. There's different policy options. There's toolboxes very often in white papers, and then the European Commission says, well, we have these specific options. And then there's also public consultations, and I think it would be very important to keep an eye on public consultations, especially for in the DSA, there will still be some so-called delegated acts. So these are going to be more specific norms that will implement some provisions from the DSA. And I think so with Jakob, we have been participating in some public consultations, and it's a very nice way of interfacing with public policy and also sharing thoughts from a specific perspective when it comes to, regulation that is currently on the table, in this case, in the European Union. And then, of course, there's a lot of different procedures and processes that this type of regulation still needs to go through and to be adopted by the Parliament. You can see that there's also a very big role for political negotiations and also political alignment, and that is something that is part of the public policy cycle. But also important to know that there is this policy cycle that the European Union always needs to go through when coming up with new regulation. So basically, the idea is that the Digital Services Act is supposed to update the e-commerce directive, and it's supposed to bring to the European Union an updated regime for providers of online services, basically intermediaries, and understanding what kind of responsibilities need to be placed upon them, and exactly how these obligations can be enforced. So as I was mentioning earlier, we also have, this is the e-commerce directive. This is Article 89 of the DSA. And what happens is that these articles relating to the hosting, caching, and mere conduit intermediary activities, they have been taken over and included in the DSA. And why is that important? Because basically, in a nutshell, the DSA doesn't really very much change the earlier regime when it comes to intermediary liability, but it just very slightly updates it. So in addition to that, we also have new transparency provisions, and also new self-regulation nudges. But also there are in the DSA, and we saw this also in the interest that you indicated in the forms that you submitted to us, that basically there are some provisions that are quite randomly added to the DSA. So for instance, a provision on dark patterns, where exactly is that coming from? But there was a lot of lobbying about dark patterns around the DSA. And for instance, targeted advertising is another one, which is not necessarily placed under the heading of this intermediary liability framework that is taken from the e-commerce directive, but is just new advertising provisions that have been developed in the DSA. And then I think this is what also helped me at the very beginning dealing with the DSA. This is the structure of the DSA. We're going to talk about the liability in a second and come back to this. But basically, we have these are the kind of the main three pillars, if you will, of the DSA. We have the liability of providers of intermediary services, and most importantly, the fact that actually providers are not going to be liable for content that they host, that they cache, or that they intermediate through mere conduit on the internet under certain circumstances. And this is, again, a regime that is being taken from the e-commerce directive and then slightly adapted by the DSA. But the revolution is actually here with due diligence obligations for transparency. This is also kind of the chapter where we have a lot of different new provisions, for instance, like the provisions on dark patterns. So basically looking at the actual interfaces of digital platforms. And then we also have the enforcement part, which is quite extensive and which I should mention will require also additional regulation at national level. Maybe it's important to also say that the DSA is a regulation. So in European law, the word regulation has a very specific meaning, namely that it is a type of law that once the European Parliament adopts it, it is completely applicable as such through all member states, as opposed to a directive. So the e-commerce directive, which is a law that every single member state still needs to make a national law to implement that directive. So that's just to clarify that. So here, although we're talking about a regulation that sets out the competences of these particular types of stakeholders that we will discuss in webinar 3, there will still need to be a lot of national administrative law about who does what and how to divide tasks and how to actually implement the enforcement part of the DSA. And Jacob has been in contact, for instance, with the Dutch Digital and Service Coordinator. And Jacob, do you have anything that you want to share with us from those experiences?
Yes. So I think for all digital service coordinators, but probably also for the Dutch one, the DSA is huge and it encompasses everything. So the different definitions of illegal content encompass everything. So that can be anything from copyright infringing content to child pornography or child sexual abuse material, rather. And the digital service coordinator now all of a sudden needs to deal with that. And you need to remember that digital service coordinator are usually existing entities, such as in the Netherlands, for example, it's the Consumer Authority. So they're not necessarily equipped to deal with all of these questions. So for them, this is also a huge challenge of trying to figure out what are the different risk assessments that we need to provide for as digital service coordinator. What are the services that we need to provide for as digital service coordinator? how are we to create this whole sort of enforcement institution out of just thin air within a couple of months? So much of their approach has been, okay, we'll just figure it out as it goes. But yeah, I mean, for them, this is also just sort of an exploration in itself.
Yeah. And more than that, not just an exploration, but also an exploration that will require additional legal instruments, because we will talk about this towards the end of the presentation. But for instance, if we're speaking about data access, and this was also one of the points that some of you wanted to discuss. So data access, there's going to be a regime for vetted researchers that are going to be granted data access by means of, first of all, being kind of appointed as or being recognized as vetted researchers, and then it's going to be the digital service coordinator, national digital services coordinator, that will have to do that. So there will need to be additional rules that will say, where do you have to be a researcher from, and how exactly, what's the procedure, what do you need to submit to this the digital national service coordinator to actually become a vetted researcher. And then also, because this is going to be something that most likely is going to be kind of reviewable, you know, where can you complain about this? Who should decide on your complaints if you have been, for instance, like denied access as a vetted researcher and stuff like that. So a lot of laws also need to be nationally undertaken here. Yes, that sounds like a very long process, Rebecca. And I think yes, so and Roel, you were mentioning, yes, the ACM, they are definitely going to be the new National Service Coordinator. And for those of you who are not familiar with the ACM, that's the Consumer Protection Authority in the Netherlands, that will also be the ACM authority. And this is where, especially with the transposition and the enforcement part, it's going to be, pardon my French, a shit show, because there's going to be in some countries, some authorities that, for instance, are the telecom authorities, in some countries, the media authorities, and in some countries, the consumer authorities, which will now fulfill also the DSA role. And these are authorities that have very different cultures. They have very different procedures. They also are used to very different laws and very different work styles. And yeah, I once spoke to someone from the French telecom authority that is also going to now perform the ARCOM, so that's the media authority, that will also perform the DSA coordination. And it's a very different atmosphere in that authority than it would be, for instance, in the French Consumer Authority. So this will very much influence the way in which the DSA is going to be implemented. So that is going to be very, very interesting, but we have to see exactly what will happen. Now, going back to Daria's question, because I think, hi, Daria, and hope everything is well on your train ride. So we are talking about the liability of providers. This is, if you will, and again, Jacob, please correct me if you disagree with that, but I would say that basically like this liability of providers part is more like, how is content moderation done, and when exactly, like what do platforms actually need to do to moderate content? Because there's a lot of new procedures with notice and action, a lot of dispute resolution procedures that are available in that part. But the actual liability regime stays the same from the perspective that we have this kind of limited liability, if I should say it like this, for online platforms that only is triggered under certain situations. So then if you get notified and you do not take measures against illegal content, and we will come back to this absolutely atrocious term that is very important. If you do not take any measures against illegal content that you have been notified or that you're supposed to know about, then your liability gets triggered. But otherwise, in principle, the idea is that you have, as a hosting service, as a caching service, as a mere conduit service, you have this exemption from liability. And this is basically the nice part of the DSA, and also the fact that it takes the e-commerce directive regime, that it's not really a lot of liability, but it's just, there are some moments when this liability can be triggered. Yes, so basically,
can I add something?
Yeah, please, of course, absolutely.
Just trying to add to the note in the chat about the copyright directive in the digital single market. So there's two different liability regimes here. And under the Digital Services Act, as under the e-commerce directive, you're liable upon having knowledge of a type of legal content on your platform. And that knowledge can be construed either by having received a notification or whatever. And that triggers your liability for not taking prompt action against that type of content. Under the copyright directive in the digital single market, the presumption is that you have knowledge, regardless of anything having happened. And if you as a platform say, well, there's no way we could have known this, you need to actually show that you have taken all sort of necessary precautions against copyright infringing content, and only then can you be not liable for hosting copyright infringing content. But copyright has, for some reason, always been at the forefront of liability regimes on the internet.
Yeah. So it has been a very important sectoral area that has led to also a lot of focus being placed on copyright, unfortunately to the detriment of other fields, but that is a different conversation. But basically, just to summarize, Daria, so we have liability that is triggered basically only when there is this actual knowledge. So in the e-commerce directive, there was this requirement of actual knowledge, and especially in the mindset of the 2000. Actual knowledge, you can absolutely construe that as a notification. So maybe someone informing, like the police informing or a user informing upon using different reporting mechanisms that indeed there is, for instance, let's say terrorist content on a specific platform. But the problem is that now with all of these new machine learning and generative AI and humongous improvements in artificial intelligence in general, all of these developments now also beg the question, well, what are platforms doing? Because they actually know quite a bit of what is happening on their platform because they're doing moderation, right? So they're also offering moderation as a service. And this is where we have this new provision, this Good Samaritan protection, which is mirroring some developments in the United States in Article 7, which is new compared to the e-commerce directive. It's a very explicit admission that even if you are actually really by yourself looking at content and analyzing content on your platform, if you're Meta and you're doing automated analyses of this content, you're not going to be as such liable for this content. But that also comes from the fact that then you need to do something about removing illegal content. And this is very important to be linked to Article 8. So this is probably one of the most important aspects that has been also taken from the e-commerce directive in the DSA, in this kind of more content moderation framework, that we're speaking about no general monitoring or active fact-finding obligations. What does that mean? That actually no member state may impose on platforms, on service providers, an obligation of monitoring their content. And why is that, Jakob? What do you think is behind this provision?
Fear.
So not of roller coasters.
So the idea behind the general monitoring the prohibition for general monitoring obligations is that it's twofold. So first of all, general monitoring will happen automatically, so it's not risk-free. Like artificial intelligence will mislabel content and remove it despite it being perfectly legal. The second sort of prong why it would be considered problematic is that under authoritarian regimes, it can be used to silence opposition. And therefore, there's also a prohibition to sort of force platforms to scan all the content that they have. But it's a provision, and I'm sure we'll get to this, that courts and regulators have been struggling with.
Yeah. And for instance, there has been a case at the Court of Justice of the European Union that has specifically looked at this general monitoring duty. And I think that this is one of the most important cases. And perhaps, Jakob, do you want to summarize it really quickly?
Yeah, sure. Really quickly. So the case that Catalina is referring to is about an Austrian politician, Eva Klawischnik-Piszczek. I'm sorry for butchering the name. And she was subjected to online abuse, essentially. She went to court trying to sue Facebook to more actively combat the abuse that she was subjected to. And in the end, the Austrian court decided that Facebook should actually remove all posts that were defaming Ms. Glavischnik-Piszczek, but also scan for identical content and remove content that was similar to the content that was considered defamatory. And this is interesting because this is sort of stretching into the realm of general monitoring obligations, because now platforms do not only have to scan for identical content, which is fine, because then a judge has already decided that the content is illegal. A platform doesn't need to make its own consideration of whether it's legal or not. They just need to remove it. But the Court of Justice decided that the nature of hate speech or of defamatory content is such that similar content could as well be just as harmful, and therefore Facebook needs also to scan for defamatory content that's similar to the content that was considered illegal. So now you're getting this quasi general monitoring obligation, which is sort of it creates a tension, as does Article 17 of the Copyright Directive, Copyright and Digital Single Market Directive, by the way, because it also has this provision that you're liable unless you take all necessary precautions, and all necessary precautions would then include a general sort of monitoring framework to filter copyright infringing content. So yeah, it's every sort of court tries to find its way around the general monitoring prohibition.
Thank you so much. And actually, I think that there was a Wired article, I have to try to find it again, but there was this Wired article that was just so incredibly offensive towards the Court of Justice after this judgment, because they were like, you don't understand how content moderation works, and you don't understand how social media platforms work, because basically it is a little bit of a contradiction, you know, in terms of, you know, so for instance, the specific wording of the court was, okay, if you have identical information, so let's say that the same post with the same insults resurfaces, which is very much the case in a lot of hate campaigns, then of course then the platform really needs to take it down. But then what if it's a similar, like what if, you know, there's a synonym for the racial slur that was used in the first one? Then in principle, you know, you would need, I don't know, a new legal assessment to start off with. But then also, how do you identify it if it's not exactly the same post? But if it is just a very basic modification of that post, then you can also say, well, that is something that you can generally monitor for, but there will be some degree of an independent assessment necessary. But yeah, how does machine learning work, and how do we combine the findings of the court with this machine learning reality that we have nowadays? But this is a very good example, and a very good, I think, transition to some examples of provisions, because the reason why we added here, particularly these laws. So we have hate speech, we have insults here on Facebook on the post that was tagging this particular politician, and we have two specific legal grounds, one which is more in the copyright direction, and one which is more in the civil law direction, continental civil law. So the idea of image rights, and also the idea of defamation. So now a court made this assessment that yes, this post is a violation of that particular legal framework in Austria. And that means, and now under the DSA, it used to be the word like illegal information or illegal activities under the e-commerce directive, but now under the DSA, we have the term in Article 3H, illegal content. And illegal content is literally anything under the sun. It is content that is it can be by itself, or it can be an activity. It includes the sale of products or the provision of services that is not in compliance with EU law or national law that is in compliance with EU law. So basically, on the basis of the fact that a post would be defamatory under Austrian law, that means that it is illegal content under the DSA. Does that make sense? So it's like you have a country that says we cannot deal with this, to the extent that that law is not considered unconstitutional, or it's not considered to be against or coming into conflict with EU law, then by all means, this is basically going to be illegal content. Other examples include, for instance, influencer disclosures. If you have a specific legal framework like the Unfair Commercial Practices Directive that says you need to disclose advertising, and you don't disclose advertising, that is illegal content. Any content that can be considered harmful under the Audiovisual Media Services Directive, for instance, content that can be considered to affect the children's physical or mental development, that can be considered to be illegal content. And then when we have illegal content, there will be quite a lot of responsibilities for platforms, which brings us to the DSA database, because a lot of the moderation of illegal content is now, especially by very large online platforms and online search engines, there is already an obligation to submit what are called statements of reasons. Basically, decisions of doing something with the content. So Daria was also asking, is it just like takedown, or can it be also anything else? It can be anything else as well. So for instance, it can be taking down content through geo-blocking, so only blocking access to content in a specific country, as was also one of the problems under the Glavišnik-Pieček case. So yesterday, I think we were at 608 million statements of reasons. Now in February, when all online platforms are going to have to put up their statements of reasons, it's gonna be insane. So I don't know what comes after trillions, but we're gonna see that probably somewhere in the course of 2024. So that's going to be quite interesting to notice. And just to give you some examples, you can have a look at these analytics on the website. But yeah, so TikTok has been very active. Like TikTok has been so active that it's almost like a denial of service attack. Like it has been uploading so many different statements of reasons on the platform. But also Facebook, I think, has been uploading a lot, and Google Shopping for some reason. And then we see basically illegal products. So this deals with, for instance, products that are considered to be harmful for consumers. Like products that are supposed to be taken out of the market because they are, I don't know, toxic or something like that. Then we have illegal or harmful speech and pornography or sexualized content. This is, for instance, another used category. But this is here something that you can just look through these statements yourselves. There are quite a lot of procedures that platforms need to put into place to be able to allow users to report the illegal content, so for them to do something about illegal content. There's also trusted flaggers, which is the topic of Jakob's PhD. So institutions, all sorts of institutions that can report very specifically illegal content. But very importantly, there's also this very, very new provision of Article 34, risk assessment, where very large online platforms and search engines will need to identify their systemic risks. And illegal content is the core of one of the systemic risks that the European Commission elaborated upon in the proposal that stayed on also throughout its adoption. Basically, the dissemination of illegal content through their services. So when you disseminate illegal content, you don't necessarily do something to moderate illegal content, and that can lead to a systemic risk. Now, I take you back, and I really have, if you have any questions and any kind of remarks on this, or would like to express your sheer shock, as I do sometimes, and also in my own writings, basically that imagine that illegal content can be anything. So systemic risks in the meaning of this particular provision can also mean literally anything. So that is quite scary. Article 40, the third thing, and this is the last thing that I would like to mention. With data access, this is also something that some of you were interested in. So a novelty is the fact that here in Article 40, we have two layers. We have a layer of, data. So all of these very large online platforms and very large online search engines will have to open up to, first of all, authorities, so digital service coordinators. For instance, if you look at subsection 3 of this article, but at the same time, and subsection 2, but at the same time, we have also data access under subsection 4 for vetted researchers. So then we have to see how exactly this is going to happen at national level, that researchers just like ourselves could perhaps start looking into these systemic risks and start defining them further on the platform. And Paddy Larson, who is a postdoctoral researcher at the University of Amsterdam, at the Information Law Center. He made a summary of all of the public consultations on the data access delegated regulations. So the delegated regulations are these very specific, very specific rules that will implement Article 40. So they will be applicable together with Article 40. And here he made a very nice overview of all of the things that 133 researchers and mostly have mentioned they need in terms of data access for vetted researchers. So that's something that I would absolutely suggest that you have a look at. And next week, so I'm going to kind of conclude here with the presentation so we can start a conversation. But and then actually, first of all, allow Tom and Taylor to reflect on this from a media studies perspective. Next week, we are going to dig in some more under the recommender systems provision, Article 27, also looking at the terms of service, and particularly discussing this in the context of TikTok compliance. So I think if we haven't done that already, we will share the slides with you. And but Tom and Taylor, what do you think about the DSA?
Oh, a lot. Yeah, thank you so much. Let me just share some of our provocations to start to think in more in the context of media scholarship. Just a second. Okay, so sorry. Okay, so yeah, we want to offer you some key concepts for thinking about this amazing pool of insights that we just got from Catalina and Jacob. And Taylor, you want to kick off our provocations phase?
Yes, I think a lot of the kind of thoughts that we have in response to hearing Catalina and Jacob's articulation of what the DSA is about really chimes in with the discussion we've already been having through the chat and that sort of thing. So hopefully these resonate in terms of the reflections that we've been having in terms of what this might mean for media studies scholars. And what we've tried to do is anchor our provocations around particular key terms that emerge from the DSA. So I guess firstly, in terms of content moderation, I guess thinking about how social media platforms create and enforce these rules about what content can and cannot be posted on platforms is an object of study that has been of great concern to media studies scholars, particularly in the kind of work that's emerged in platform governance. And so here we're thinking about how this kind of way of framing what content moderation or what content should be moderated in the DSA through this lens of either thinking about illegal content and how we might problematize what that means in this context, but also in the way that the DSA approaches content moderation through the enforcement of the platform's own terms of service. And I know this is something that we'll come on to in our next webinar, but kind of potential issues that might arise in relying still on this kind of private governance approach to what the platform considers to be the right kind of content to be moderated in this space. And so for us, we have kind of questions around, what forms of moderation might still be overlooked if we take the approach of the DSA and thinking about illegality or thinking about the platform's terms of service, and what kind of experiences or implications of moderation might emerge for particular groups of users. And connected to this, and perhaps Jakob, you might have some specific thoughts. How does the DSA construct a relationship, I guess, between content moderation as enacted by platforms and the protection of the fundamental rights of users? Where do these two things kind of intersect within this particular regulatory framework? Then I'll hop back to Tom.
Yeah, so to keep throwing some more brain candies for us to think about when we think about, like, as media scholars about the DSA, Taylor and I were also curious about the risks for users. So we kind of believe it's crucial to look into this conceptualization of the user as we say it, like as a generic entity in the context of the DSA. Along with the associated risks and rights that it might acknowledges or fails to recognize. So we we think and we question, how does the DSA define creators, minors, or even viewers? Are all groups adequately represented, and should they be like represented in the DSA very specifically? And how might our expertise and understandings of group be beneficial to identification and assessments of risks? And what kind of empirical research can we as media scholars conduct to further probe and test those definitions?
And then, of course, the very loaded term transparency, which the DSA nicely mobilizes. I guess there we have questions around, how do we approach these kind of acts of transparency in terms of this transparency database with these moderation decisions, as well as the kind of provision that means that we now have access to like ad archives and more details about the targeting of advertising on platforms. How do we engage with some of this data that has become available in ways that are meaningful? How do we make sense of kind of new wordings that emerge in response to the needs for platforms to be more transparent with their users? So I'm thinking here about terms of service. What does it mean to adequately inform your user about how a recommender system is working, for example? And then I guess in terms of this kind of what emerges around the vetted researchers, how might us as media scholars, researchers contribute to kind of collaborative and interdisciplinary research that will be going on as we gain access through provisions in the DSA.
And before handing the discussion again to all of you, all of us in the crowd, and Catalina and Jacob, one last provocation about algorithmic systems for personalization and targeting. So we're thinking that given that the DSA addresses the operation of recommender system and targeting of advertising, we see scope for media studies scholars to speak of how the concept of fairness is operationalized. Also, thinking about personalization in the case of TikTok and the platform's compliance to the DSA with the promise to give the option for depersonalization. What does it actually mean, and how realistic would it be? Like, imagine TikTok without personalized feed. Like, why should we even go on TikTok? So let's try to think what types of empirical research is needed to understand impacts of users, and how might existing insights on algorithmic imaginaries or gossip be brought into dialogue with legal instruments. So now we'll be happy to hear your reactions, Catalina and Jacob, interconnected with our crowd's voices.
That's fantastic. Jacob, do you want to talk about this idea of having, on the one hand, really, for instance, in the field of fundamental rights, having, this very case-by-case basis approach of understanding what individual rights should be interpreted like, and then this the tension between that and the fact that we have these platforms, we saw the scale at which they operate, but also the pressure of themselves kind of determining and interpreting the law that sometimes is even unclear for seasoned judges. Like, what is this tension to you?
Well, I think that sort of hits the nail on its head. The platforms have struggled with fundamental rights, and I think because I got to thinking when we just heard about sort of protecting the user, and I think that there's not such a thing as protecting the user, it's protecting the users. I think the sort of the concept of the individual user on social media it's almost dead. And the DSA is an example of that. The DSA is a risk-based regulation, meaning that it tries to mitigate risks that stem from the use of social media and the services that provide us access to that social media. That means that sort of all the risk assessments and all that, and the whole liability system in itself is based on the idea of, okay, well, things can go wrong, but as long as we try to make it better and make sure that they don't go wrong all the time, then platforms are doing what they can. Because I think the DSA in itself acknowledges the fact that it cannot be perfect. And that creates a tension with fundamental rights, because the idea of fundamental rights is that you protect the individual, and the individual has all kinds of freedoms. and that individual needs to be protected from state abuse regarding all those freedoms, which is a second tension. Because can we expect from privately operated platforms that they adhere to all the same safeguards as the state does? Do I have the same freedom of expression as I would do vis-a-vis the Dutch government, as I do vis-a-vis Mark Zuckerberg? Imagine that I send a letter to the newspaper has no obligation whatsoever to publish it. Why can I expect the same thing from a platform? And the tension there is that, well, we've come to this situation where we have this sort of, well, I read this interesting term today that was coined by Luciano Floridi in 2015. We have this on life. We cannot sort of take part in society and socialize anymore without actually being online and taking part in these platforms, which places these huge burdens on platforms to, in some way, fulfill some sort of state-like functions, which is where that tension stems from. But I think we need to rethink fundamental rights in the sense that they are collective rights. As a user, we have a right that platforms try to make our lives as good as possible, but we cannot expect them to be perfect. And sort of any regulation that says that it can be perfect is probably utopic or wrong. But that's, I think, my sort of take on it.
Thank you. And what are your thoughts? What kind of questions do you have? Also linking to the excellent remarks of Tom and Taylor of linking media studies to the DSA.
Right. Yeah, sorry, I forgot that part of the question. I think to me, sort of, first it lies in describing why social media platforms are so much different from anything else that we have. So they're not traditional media, but they're also not sort of the state providing us democratic discourse, but it is something. What is it? How do people use it? And how does that usage warrant sort of regulatory intervention? I think that's sort of number one, that's at the basis. But then now thinking about the DSA and the protection of users, I think it's also in describing groups of users as opposed to individual users. So I think we need to move away from this concept of individual rights and move towards collective rights. How does that look like? Let's say we depart from user and go to users. How do you describe groups of users? What does that look like? And how does that sort of translate to any sort of regulatory intervention? So I think there lies, at least to my research, the most sort of fundamental contribution, aside from, you know, all the work that you can do in describing and making sense of current trends, which makes sense to like no legal scholar. I think that's, to me, sort of the main contribution of media studies.
I see Dan also had some comments in the chat. Do you want to elaborate on that, or anyone else? I see Rebecca also has a point.
The difference between mainstream media and social media is that the social media users can be both producers and consumers. I think that's one of the differences. And also sometimes social media has stronger or stricter censorship. The recent one is the letter to America by Bin Laden, and it was a craze on The Guardian, and The Guardian took that down, and also on TikTok, and the TikTok took that down.
Yeah, so I think that when it comes to the consumers and producers, so that's also, there's a term called prosumers. And I see Laura is also here with us because she's actually looking at social commerce on social media platforms. And indeed, there's a very big development, and even the DSA acknowledges this dimension of commercialization, because the DSA also is applicable to, for instance, marketplaces, not just social media platforms. But for instance, I think that this example that you're giving with Letter to America is very interesting because from a legal perspective, you can also say, well, newspapers are actually have an editorial responsibility, and the editorial responsibility is also their own discretion. So they can choose to publish something or they can choose to not publish something. And that's based on their own interpretations of the prerequisites of their editorial tasks. Whereas social media, you can say, and this is where the private governance comes into play, you can say that a social media platform could make an evaluation that this type of a letter could perhaps be interpreted by a court as incitement to hatred or incitement to violence. And then if that is the case, then that is illegal content. So then a platform is going to be very much, okay, we need to have a risk assessment approach, this systemic approach that Jakob was also talking about. We're going to take that down because we want to have, and then of course you have like platform values and platform interests as well. But this is also part of the discretion that a platform has, because every single user is on that platform on the basis of a bilateral contract with the platform. So I'm personally a very big proponent. Jakob is already smirking because we had endless discussions on this. I'm a very big proponent of looking at platforms as what they are, namely they are shops. They are, particularly social media platforms, they are spaces that have created this mirage that they are about the public square, but you have companies that have underlying interests that are fundamentally commercial. So I think that from my perspective, it's very important to acknowledge that. Because with that comes this limitation of saying, okay, you don't want to interact and have a transaction with me, go and interact with the next social media platform that you can see that might have other rules that you might be, comfortable with. Yeah, Tom and Taylor, do you want to do the moderation?
Claudio, would you like to join the discussion?
Yeah, thank you. I have another aspect that I didn't hear mentioned today. It is about the creation of special access for researcher. I believe it's Article 40 and 42. One of the critical point I try to pitch among researchers is that I worked in the past years with the University of Amsterdam to develop tools that allow social scientists in studying the algorithm. So the project name was Algorithm Exposed, was under ERC POC of media studies and the project Data Active. And we built technology to analyze YouTube, Facebook, Amazon, and others. And what emerged is that in order to be critic on platform behavior, you need to do external analysis. Every time you saw those platforms provide access to researcher, they were deciding which kind of data, which kind of license give to this data. And that was implicitly going to limit also the research potential. One of the most subtle way to see this is, for example, when Facebook gave access to a researcher, what the researcher can analyze is what people publish. So, for example, you have the post published, the comments, how many likes they take, and in technical term, it's like the unique identifier of this database was the post created by the producer. And that is also define what kind of research you can do. You can research on the content. But if you want to investigate on the power of the platform, so the algorithm, the fact that one post to me has been shown 3 times and to you 0 times, it's clear that the kind of data need to be different. And they don't give you that. So having those articles that somehow need between the authority and the company to agree on which data they need to be, they can be accessible for researcher and they have to validate your research question, I believe is not really letting us address the true power of the platform. It makes you do some progress in analyzing the communities, but the communities made by people, their culture, their bias, their problem. But the platform in between is also deciding a lot, and we don't have tool in that sense. I don't know. I wonder if you have opinions, because is a difference between believing that DSA is the ultimate silver bullet to test platform, or that is us a step, but we also need to keep tools that make you do independent analysis. And that means do the scraping, do reverse engineering, and do more technical action that tendentially universities are also afraid to undertake because they're afraid to be sued.
These are absolutely fantastic points. And of course, we didn't have time to go into the nitty-gritty details of Article 40, but what is very important to know is that together with Article 40, we also have Article 37, which is about independent audits. So I think that also from a research perspective, we need to understand what exactly is researchable from the outside of the platform, what is researchable from within the platform. And my personal opinion is that currently, what I see, so I'm connected to some computer science communities where I see very in-depth quantitative methods that are being developed that work very well for instance, it can be very good for algorithmic auditing. For instance, Solon Barocas from MIT research, from Microsoft research has been working very much on that. Then you have, for instance, computational social sciences. You have also media studies. You have so many different disciplines that have their own perspectives and their own methods. And so far, I think as the research community, we're not really very harmonized in terms of even talking to one another from one silo to another. I see this all the time that computational social sciences don't really cite computer science research very often, and vice versa. Not to mention vice versa. But the thing is that we also need to think, you know, is this something that a research team can actually do? Auditing the actual recommender system of TikTok, or should we leave that for the independent auditing, which is supposed to be an obligation of opening up your entire store, your entire TikTok platform to a company? And there, of course, we have the risk of, you know, is that going to be like a Big Four company? Is there going to be conflict of interest, etc.? Because that's where literally you have hands off as a company, and you need to let those investigators look at whether you have been doing your research looking at systemic risks. And that would be more of this systemic approach of, you know, the architecture of an algorithm that would be perhaps a little bit too much for independent researchers in smaller teams. But just just
to be minded with time as we are approaching the end. Maybe just a quick response for Rebecca. Rebecca wrote 2 messages with lots of insights.
Sorry, I just threw things in, but this is basically like what I've been thinking about like over the last weeks. Just like looking at what's happening now and continue. And I don't have an answer for it, but I'm just like amazed by how platforms already figured out a way to just like, I don't know, to like find another way how they can make use of a law that should actually regulate them. But in the end, they're like, hey, here's a choice. You can pay $14.99 per month without ads. Nobody wants that. I don't know if people actually, you know, be like, yeah, okay, that's cool, I'll do that. Would be interesting to know, also something to research. But yeah, I'm wondering how this will continue in the future with coming changes. But yeah, and thanks to all of you, especially Catalina, for the really nice overview.
Great. Lovely. Okay, we are reaching the end of our session. Maybe Catalina, just a quick taste for what is coming to us in session 2 and 3, for people to have a bit of a teaser towards that.
Recommender systems is what's coming, and also with some very specific examples of looking at the terms of service of TikTok. And depending on also what you are interested in, if you would like to discuss also additional provisions, because we thought that if we focus on one specific provision, we can discuss it more thoroughly. But for instance, if you're also interested in trusted flaggers, let us know, because then Jakob can also present something on that. And the thing is that every single angle of the DSA is just so complex that, yeah, we try to make some choices, and I think that recommender systems are going to be the topic of our next webinar.
Great. So that was the end of the first roller coaster ride. We're gonna hit another journey next week. We will be sending the recordings of this meeting, and we will also promote more information towards the next session about what we're going to unfold and discover together. And that was a great way of spending time this evening, our time zone, but maybe other time zones here. And thank you so much, Catalina and Jacob. Thank you, Taylor. And thank you for everyone for joining us. And we'll be shortly in touch via email, Twitter, Blue Sky, Mastodon, Airlist, and everything else.
Thank you so much. Thanks, Tom and Taylor.
Bye-bye.
Thanks, Jacob. Bye.